Judge Roman, do solemnly swear
I, Judge Roman, do solemnly swear
that I have not directly or indirectly paid,
that I have not directly or indirectly paid,
offered,
offered,
promised to pay,
promised to pay,
contributed, or promised to contribute any money or thing of value,
contribute or promised to contribute any money or thing of value,
or promised any public office or employment
or promised any public office or employment,
as a reward to secure your appointment or confirmation thereof.
as a reward to secure my appointment or confirmation thereof.
So help me God.
So help me God.
Municipal judges are public officials who are either elected or appointed to administer laws in cities. After swearing to an anti-bribery statement and taking the oath of office, judges can officially perform the duties of office. Municipal judges derive their authority from the Texas Constitution, statutes, and their city's charter and ordinances. One who accepts the position of judge accepts an obligation to exercise judicial authority in a manner that promotes public confidence in the judiciary. Although municipal judges work with other members or officers of the city, they still must adhere to the principle of an independent judiciary. This is the concept of separation of powers envisioned by both the United States and Texas constitutions. The court is the independent, third party that makes a decision based on applicable law. Like all judges, municipal judges must adhere to ethical standards required by the Texas Code of Judicial Conduct. The code emphasizes the necessity of the judiciary being independent and not allowing anyone to influence conduct or judgment. In all activities, the code requires judges to establish, maintain, and enforce high standards of conduct so that they avoid even the appearance of impropriety. The State Commission on Judicial Conduct, which investigates allegations of judicial misconduct and disciplines judges, issues public policy statements intended to help preserve the integrity of Texas judges. These public statements address issues such as judges not being able to serve the public as both judge and law enforcement, because this would undermine the public's confidence in an impartial and independent judiciary. Now let's look at municipal court jurisdiction. Municipal judges exercise their authority within the jurisdiction provided by statute. Municipal court jurisdiction to hear cases involves fine-only offenses that occur within the territorial limits of the city or on property owned by the city in the city's extraterritorial jurisdiction. Fine-only offenses are ones punishable by a fine and may also include other sanctions that are rehabilitative or remedial in nature but do not consist of jail or imprisonment. Next, we will look at judicial duties, which are ones that require the exercise of judgment involving questions of law, or in the instance of no jury, questions of fact. Also, judges can determine sentencing options allowed by statute. Judges have the discretion and the power to interpret and apply law, guided by the rules of law. Because judicial duties involve issues of law, they must be performed by a judge and cannot be delegated. Even if a judge is part-time and not available to handle the day-to-day operation of the court, the judge may not delegate any judicial duty to a clerk or anyone else. To better understand a judge's duties, let's look at some specific ones. Judges admit persons to bail, request and accept pleas, conduct pretrials in which they rule on motions. They also conduct trials. Judges render and sign judgments. They determine the amount of fines and how defendants pay their fines. If a defendant has been in jail, the judge must give the defendant jail credit on his or her fine. If a defendant fails to pay a fine, a judge enforces the judgment by issuing a capias pro fine. Before issuing a warrant of arrest, capias, or summons, judges must determine probable cause. When defendants fail to appear, judges declare a bail forfeiture, which initiates the process of forfeiting the bond. Judges conduct stolen or seized property hearings and dangerous dog hearings. They grant driving safety courses and deferred disposition. When it comes to dismissal authority, a judge's authority is limited, except in a few instances that we will discuss later in this video. Being a judge also means overseeing the administration of the court. The Texas Code of Judicial Conduct requires judges to diligently and promptly discharge administrative responsibilities and to cooperate with other judges and court staff. Although judges can perform ministerial and administrative duties, typically they delegate these duties to a clerk. Ministerial duties are those duties that do not require any legal judgment or discretion and are generally administrative in nature. Some examples of these duties are preparing and maintaining the docket, receiving and depositing fines, court costs, and fees, preparing judgments for a judge's signature, maintaining and destroying records, scheduling cases for trial, issuing subpoenas, preparing state and city reports, explaining court procedures to defendants, delivering case documents to the appellate court when a case is appealed, and managing the clerk's office. One of the most important things that judges should remember in overseeing court staff and the administration of the court is that the Code of Judicial Conduct directs judges to require the court staff to observe the standards of fidelity and diligence that apply to the judge. Now let's visit a court to see a judge conducting an arraignment, which is the process where a judge identifies the defendant and requests a plea. After being arrested on a charge of public intoxication, the defendant is brought to court from jail.
You are Angela Baumgarten.
Yes, Your Honor.
You're charged with the offense of public intoxication. You can plead guilty, nolo contendere, which is no contest, or not guilty. If you plead guilty or nolo contendere, I will set a fine. If you plead not guilty, I may set a bond and schedule you for trial. Do you understand the pleas?
Yes.
How do you want to plead?
Guilty, Your Honor.
Before I set your fine, are there any circumstances regarding your case that you'd like to tell the court?
No.
Only a judge can request a plea from a defendant and set the fine. If a defendant refuses to give the court a plea, the judge must enter a not guilty plea for the defendant and set the case for a jury trial. If the defendant has been in jail, the judge, upon conviction, must give jail credit for each case that the defendant spent time in jail. Some defendants, upon pronouncement of the amount of fine, indicate that he or she is indigent. The judge must then conduct an indigent hearing to determine the defendant's ability to pay the fine. Let's see how a judge handles this.
You have pled guilty to the offense of public intoxication. The fine, along with costs, is $150.
I really can't afford that, Your Honor. I don't have any money. I really can't pay that.
Okay, then I need you to complete this financial information form, and after you've completed it, come back in.
Thank you, Your Honor.
After the defendant completes the form, the judge will ask the defendant to swear that the information contained in the statement is true and correct. Then the judge will place the defendant under oath and ask the defendant questions about the financial information that he or she has provided the court. Another instance in which a judge might have to conduct an indigent hearing is when a defendant has been arrested on a capias pro fine for failure to pay a fine. During this hearing, the judge must determine the defendant's ability to pay, whether the defendant willfully refused to pay or if the defendant failed to make a sufficient bona fide effort to legally acquire the resources to pay. Anytime that a judge determines that the defendant is indigent, the judge can allow the defendant to pay the fine in installments or require that the fine be discharged by community service. However, if community service works a hardship on the indigent defendant who defaults on payment of the fine, the judge may waive the fine and costs. The one thing that a judge cannot do is commit indigent defendants to jail simply because they are unable to pay. But if a defendant who defaults on payment of a fine and/or costs is not indigent and refuses to pay the judgment, the court can specify in the judgment a period of time of not less than 8 hours or more than 24 hours as the period for which a defendant must remain in jail to satisfy $100 of the fine and costs. Next, we see a judge conducting a jury trial. Municipal judges have the authority to preside over jury trials and non-jury trials, commonly called bench trials. The judge can also require defendants and the state to appear for a pre-trial hearing, which is conducted to consider motions, issues, or matters that do not pertain to the merits of a case. Now for the jury trial.
All rise. City of Midway Municipal Court, Liberty County, Texas, now in session. The Honorable Catherine Davis presiding. Please be seated.
Ladies and gentlemen, welcome to the Midway Municipal Court. You have been called for jury duty and will be examined for inclusion in a jury hearing a criminal case.
At the start of a jury trial, the judge welcomes the prospective jurors, which is called the array. The judge explains the role of the jury, gives information and instructions about the jury trial process, and administers or causes to be administered an oath to the array. The judge then explains the statutory requirements to be a juror and questions the array to make sure that each person is qualified to sit as a juror. The judge also determines if anyone wishes to claim a legal exemption from jury duty. After qualifying the array, the judge announces the case, introduces the lawyers and the defendant. The judge then explains the duty of jurors, the role of the judge, and gives instructions to each juror to follow throughout the trial. During this explanation, the judge emphasizes the importance of a fair trial. Now both the defendant and state can question the array, with the state proceeding first. This questioning is called voir dire. It is at this time that if either side feels that a prospective juror is biased, the person may be challenged. The judge calls the person before the bench to determine if he or she can be impartial. After all challenges, a 6-member panel is selected. These 6 jurors must take another oath administered by the judge or under his or her direction. Now the judge directs the prosecutor to read the complaint, unless the defendant has waived the reading. Then the judge takes a plea from the defendant. Also, witnesses are identified and sworn. Before the presentation of the evidence, both the state and the defense can make opening statements. The state may make the first statement. If it does, then the defense can make a statement unless he or she chooses to wait until the prosecution presents its case in chief and the defense presents evidence. During the trial process, the judge administers an oath to witnesses, presides over the conduct of the trial, rules on questions of law, and maintains order and decorum in the courtroom. After all the evidence is presented, the judge charges the jury, and then both sides present argument for their respective cases. After argument, the case is submitted to the jury. If the verdict is not guilty, the judge renders a not guilty judgment, dismisses the case, and discharges the defendant of any liability. If the verdict is guilty, the judge renders judgment and imposes a fine and costs. The defendant may pay the fine, make a motion for new trial, or appeal. Defendants have a right to a jury trial and must waive that right in writing if they do not want one. When a defendant waives a jury, the judge hears the evidence, decides questions of law, and renders judgment based on the evidence presented and the laws that apply to the case. Although defendants have a right to a trial, many defendants choose not to contest the charges against them. These defendants choose to waive a jury trial and plead guilty or nolo contendere in open court, by mail or by delivering the plea and waiver to the court. In non-record municipal courts, defendants may also appeal after a plea of guilty or nolo contendere. Let's see how a judge handles mail-in payments and payments delivered to the court.
Judge Roman, here are the payments that I received yesterday. These came through the mail and these were delivered to the court.
Thanks, Nancy. Do you have the paperwork that goes along with the file so that I can review them? And are the judgments prepared as well?
Yes, sir. I have attached the receipt to the fine payment. I do believe that everything is in order.
Although clerks receive and process pleas and fine payments, only a judge may accept the plea, waiver of jury